Welcome to Probate Weekly. I'm Bill Gross at Bill Gross Probate on social media or BillGrossProbate.com. We do this every Thursday morning live, 9 a.m. Pacific time. You can register at probateweekly.com if you want to jump in on the Zoom call. And the goal is to be participative so you can learn more by asking questions. And it's an interview format generally. Today, we're really lucky to have one of the leading probate and estate planning, I think also probate litigation attorneys in Southern California based in Long Beach, Paul Velasco. And before we start, I just want to share a story how I came to meet him to really challenge those of you watching to improve your professional standards. Like most realtors, I went to a networking event with the idea of getting business, right? We always look to get leads. And it was the PFAC, Professional Fiduciary Association of California. It's like a monthly event in Long Beach. And there's chapters around the country and such. And Paul was a featured speaker there. And I went through the idea of meeting attorneys and getting leads. And boy, there's so many realtors there, and it really wasn't productive as far as networking. I thought, in a sense, it was a waste of time. But his presentation was on a very narrow piece of probate law that's primarily in California called the Hegstead petition. And what struck me was, first, he obviously was a master of the material. Second, what struck me was he actually gave handouts to other attorneys in the room. Now, they're also non-attorneys, which I'm sure are also prospects, but other attorneys in the room had his actual filings. Now, filings are public record. Theoretically, anybody could look them up, but he was so giving of the information to the audience. And I always felt that the best way to earn business is by educating your customers to be better customers of you in the long run. He really struck me as the gold standard. And I'll be honest with you, I haven't got any business from Paul. I'm not saying that to complain. I've actually had people on my team bring cases to his office because I think he's really, really good on what he does. But more importantly, I want to thank him publicly for being so willing to educate the public rather than just get business. How can we help our industry? How can we help our marketplace? And in his case, how can he even help his competitors be better and help us realtors bring business? So Paul, thank you for joining us today.
Yes, of course. Thank you. Thank you for having me again, Bill. I appreciate it. Always enjoy the opportunity to be on your platform, and I really respect what you do. You have a lot more probate knowledge than most professionals who are not attorneys and who don't work in this area of practice. I appreciate the kind words and the introduction, and happy to talk to you about probate from in my world.
So one of the things, and we've been on before, but so we can go a little deeper than we have in the past. One of the things that struck me about you, I know there's some attorneys who do estate planning only and don't do litigation. Others do litigation and don't do the estate planning. I know your firm does both. And I watched in your presentation, there are a couple times where you're presenting about how to do a Hegstead petition, but you knew that there was this pitfall or that pitfall, and that's why you wrote your estate plans to avoid that pitfall. It seems to me that you could make either case philosophically. Share with us why you've chosen to do both, not just for more business. I know that's not the answer, but it seems to me that the fact you litigate makes you a better estate planner to avoid those problems.
Yeah, there's no question about that. When I first started out in my practice many years ago, I chose to focus on the transactional side of trust and estates work. And so estate planning became a big part of that. Trust administration when people pass away and helping trustees carry out their duties and responsibilities was also a big part of that. But more and more, as I was, my practice was proceeding, I would get calls from people who had disputed matters that they wanted me to represent them with. And for a year or two prior to focusing on trust and estates, I had done some civil litigation. Didn't really care for it too much, but I was familiar and familiar with working on disputed matters. So it wasn't a foreign area to me to deal with court work. And more, I started to take on those kinds of cases. And I started to realize that the litigation in the trust world is really different from the civil world. There are a lot of aspects of the civil litigation that I didn't really care for and still don't. But in the trust and estates world, things are different. And so I decided to start focusing on that area of practice as well. And so I started taking on matters as they came to me, whether it was transactional by nature or litigation, and started focusing on that. And now a big part of our practice, I would say at least 50%, is trust and estate related litigation. And you're right. Being on both sides of the fence makes you a much better planner. So being able to know what the arguments are going to be on the other side, what the problems are going to be on the other side when someone dies, someone who's creating a trust or a will, knowing what, given the circumstances of this particular person, what the potential fallout is going to be. It's going to allow me to craft that plan in a way that minimizes litigation later. And, where it helps us to foresee what problems there may be and avoid them. So you're right. It does make you, being in litigation, being on both sides, helps me to be a much better planner.
So I'd love to get your take on this question. I have my professional answer, non-legal, which is I know that there are many, low cost, high volume, boilerplate, templated estate plans that are inexpensive, that get something done. And then a lot of attorneys put those down and say that they cause more problems. In my perspective, I encourage customers to say, look, get that done at least if you're not going to do a proper plan. Better to get a proper plan. But I would say 9% of people are better off even with a bad estate plan than nothing. What's your thought on that?
Yeah, it depends on the situation. Yes, I agree with you that probably most of the time it's better to have something than nothing, because you can work with something, and hopefully, even if the plan's not done correctly, if the trust was not properly funded, if there's provisions in the trust that are ambiguous, you can go to court, right? And you can try and get those problems resolved. But there have been occasions where it would have been better had they done nothing than what they did. It was so messy. So I've been on both sides of that. But yeah, I think it's definitely important for people to be educated about the process, what estate planning is, why it's important, and what are the problems and the pitfalls if you don't do it. And I think it can be problematic if people go to either those programs that you find online and try and do it yourself, Rocket Lawyer, or We the People, going to those outfits, those trust mills. It can be dangerous, but it might be better than nothing. I have dealt with situations where, in fact, somebody used a trust mill or somebody did LegalZoom and it worked. It was not complicated. It was pretty straightforward. And, fortunately, they got it right. But I've also been on the other side of that, where we've had to take those plans to court because they weren't done correctly. And where people thought that they were saving money because they were using, trying to do it themselves or using a paralegal, it ends up costing them, thousands of dollars, sometimes tens of thousands of dollars in court costs, to fix the problem.
I think it's almost always tens of thousands, but from what I've seen. So what would you say would be the one or two most common mistakes in plans that you see, either from these trust mills, or maybe the other problem is there are attorneys who don't specialize in estate plans that do one once in a while because the customer comes to them. It sounds like it's easy money. What are one or two of the most common mistakes you see that are in those plans that a more comprehensive overview will help avoid?
Yeah, so one of the most common mistakes is what you mentioned earlier. It revolves on the Hegstead case, the Hegstead petition, that a lack of funding. That unlike a will, with a will, when somebody does a will, there's really nothing else to do other than sign it, right? So you prepare your will, you have provisions in the document that say where your property goes when you pass away, but that document becomes effective only at death. And so all you have to do is sign it and put it away and wait until you pass away. But a trust is not so. A trust becomes effective immediately when you sign it. And it's only effective for what you put in it. So if you think of your trust as a big box into which you're creating this box, you have to put your assets in that box, or it's not going to be effective to accomplish your goal of getting everything to your family without going through probate. And so that's really the biggest problem with these plans, with people who either try to do things themselves or they go to these paralegals who don't really do the complete estate plan. They do the document, but they don't assist with the transfer of those assets into the trust. Now, sometimes those documents, even if they weren't funded correctly, have provisions in the trust that will allow me to go to court and correct that and ensure that the property can get into the trust without probating it. And sometimes they don't. And now we end up having to go through a probate anyway. So that's probably one of the biggest mistakes, is just the lack of funding, proper funding, and the lack of provisions in the trust that will allow us, even if the clients make mistakes and leave things out of the trust, that will allow us to get things into the trust later without probating it. You have cases that will allow you to do that if you have the right provisions in the trust. And many of those trust mills or plans that are done online just don't have those provisions. So that's one of the biggest mistakes.
So for those of you listening, especially real estate agents, this is the chance for us to create value for our customers. Number one, we can encourage our customers. We know how they hold title of the house. When we're talking about selling it, we can look at public records, see how it's titled. If they're thinking of buying a property, we can ask the question, and they should have an estate plan in place. But we also have the opportunity to help them get the assets, the real estate property, at least particular, included. One of the tricks I've used is when customers go to an estate planning appointment, I offer to pull the deeds, send them to the attorney. It's a good excuse to meet the attorney or the paralegal or both, and service the customer. So they have the deeds. It's a reminder to the attorney. Also, I'll follow up 30 days later and just pull the public records. Did it get put in the trust or not? Some attorneys are adamant to handle the process. Some are adamant not to. Some fall in the cracks, and hence we have litigation opportunities for Hexted. But for real estate agents, this is our chance to create value, to coordinate with the attorney as a partner, or with their staff, their paralegals, as part of the team, to help make sure the customer gets the result that they want. So let's talk a little bit about that, Paul. Do you have any problems? Look, I know realtors at times can be overbearing, at times can be too salesy, but I imagine you would appreciate if, as a realtor, I said, hey, by the way, my clients, the Joneses, are meeting you next week, your staff next week. Here's a copy of their deeds. They have the primary residence, they have this rental property, and that way you have the actual legal description, the APN and such. You'd appreciate that, right?
No question. Yeah. Sometimes clients will bring that stuff on their own. But if it's given to us by the professional who's already done that stuff for them and looked up the deeds, then I can trust that professional to have the right information, then yeah, we won't need to do that ourselves. Now, when we sit down with clients, we ask them for a list of their assets, and we pull the latest vesting deeds for all those properties and all those assets to ensure that they're in the trust. But if that work has already been done for us, it certainly makes our job easier. So yes, I think that would be great.
And if you're just checking, at least you know where to start. If we miss something, at least you know where to start from. But again, for the real estate agents on the call, this is the opportunity for us to talk to our customers, to create value for them at the beginning, pre-need, before they're selling the property. And I think it sets us up for a big victory.
Yeah.
So
let me mention one other mistake. So you mentioned, what are some of the biggest mistakes you saw? That's one of them: lack of funding, proper funding. That basically ends. The main purpose of a trust, one of the main purposes, is to avoid probate. And if that part is not done correctly, you're not going to accomplish that goal. It's going to end up in probate. So really important to avoid that mistake. But the other mistake that I see is clients, especially married couples. So when married couples do a trust, there are different ways that a trust can be set up. And a trust, as you know, is at its core, it's a contract. So it's a contract between these two people, this couple, this married couple. And this family trust, this contract essentially provides for how the assets in the trust are going to be distributed, are going to be held, managed, and distributed during 3 different phases of their lives. The first phase being during their joint lifetimes. And the trust literally has provisions that say, okay, during our joint lifetimes, these are our assets, and we can do with them whatever we choose. We have full control. We can spend, use, sell the assets. Then the trust is revocable. We can change it. We can amend it. We can do whatever we want. So those are the provisions that say what happens at the first death. That's phase 1 of a trust. Phase 2 is what happens with the trust when the first spouse passes away. There are different ways that a trust can be set up. Does the surviving spouse have the ability to still use and spend the assets freely without restriction? Can the survivor make changes? Does the trust remain revocable? Or does it all become irrevocable? Or does some portion of it become irrevocable? What changes can the survivor make, and what can they not make? What can they not do? So that's going to depend on the type of trust that they sign. And those provisions are going to depend on whoever's drafting the document. And in most cases, I will tell you, clients do not know. Clients have no idea when the first spouse dies what is going to happen with their trust. So when I'm reviewing a trust for a client and I tell them this is what's going to happen at the first death, most of them had no idea. And in most situations, it doesn't reflect what they would have wanted.
wow.
And so now they end up with a trust that they didn't really, bargain for. And when I tell them what the other options are, most of the time they go with one of those other options. So that's the second thing. That's the second phase of a trust. What happens when the first spouse dies? And unless you've read the trust and know what it says, you're not going to know what that says. So that's another common mistake that people make, is they don't choose the right trust for their family, for their situation. The third phase of a trust, by the way, is they're both gone. And then when they're both gone, everything goes to their intended beneficiaries. That's another big mistake that people make. Many trusts that I review are these boilerplate provisions or trusts in which you can just change the names out of different people, and it says the same thing for everybody. But our trusts are not like that. We tailor these trusts specifically for clients. And in that third phase, what most people miss, I would say 95% of plans that I review What most people miss is planning that can be done to protect your family when you're both gone. And these assets now go to your family, to your children or grandchildren, because a trust can be set up in a way that protects them in the future from lawsuits, protects them in the future from a divorce, and ensures that when they pass away, when those children pass away after having inherited from their parents, that those assets can then go on to their children without having to go through a probate because they didn't do their own estate planning. So there are many ways that the trust can be used to provide not only for their present generation, their children, but also for future generations as well, and then protect those people from lawsuits and from divorces and other problems that can happen in life. So most people miss that boat. Most of the trusts just provide for at our death, our trust terminates and everything gets distributed outright to the children, and everything's now in their name and the trust goes away. And there's so many missed opportunities there. So it's really important to set things up in a way that protects your family.
You know, and a reminder that if you don't have a trust, the state of California has an estate plan for you. It's called the probate court. It's expensive. It's the service level is just not quite as good as the DMV. So just imagine your entire life being adjudicated by the DMV. That's the process you go through. And there's obviously things you don't think about where, especially with blended families, I've had probate cases where somebody had children from a prior marriage. And because it was a probate, I think half the estate went to the prior marriage children. They hate each other. Both sets knew that dad really didn't want to include the other one for one penny. And so they lawyer up. I feel like they're going to war and I'm just in the middle trying to help them sell the house. So not having a probate, not having a plan doesn't solve the problem of making mistakes in the plan. You still would have a good one. So that brings me to the next question, which is, okay, so you write a plan and then life's, you're married, kids grow up, divorces, health issues. How often should somebody review the plan? It seems to me when you have any type of a major life change, new kids, new marriages, new health issues, at least think about it. But what does that look like? And how often should somebody really give kind of a top to bottom review? Hey, is this really how we want things carried out?
Yeah, so that's a good point. It's so important to review your estate plan frequently. My recommendation is at least every 2 years. At least every 2 years, you should do a review of your plan with your attorney. And we let our clients know, hey, it's important to give us a call in a couple of years, make an appointment. I don't charge for consultations. If people want to come in, do a review of their plan, we're happy to meet with them, go over their situation. Most of the time, changes don't come about as a result of a change in the law, that now you have to change your trust. Most changes in the law, most of the documents that we prepare anyway, account for the fact that laws may change. And so they're flexible. But very rarely does a law change in such a way that, hey, you have to now come in and change your documents. Most of the changes that will occur as a result of changes within the family dynamics, within the relationships within the family, people that you chose as trustees and executors and agents under a power of attorney. Your relationship with those people may have changed from the time that you signed the trust until the present time. And so it's really important to ensure that that plan still reflects what you want, still reflects the people that you want making those decisions for you, still reflects the people that you want your trust to go to or your estate to go to in the event of your death. So all of that is really important. So, and you're right, there are certain life events that may happen that you would want to contact us no matter what and determine whether a change should be made. But at least every 2 years is my recommendation.
There's a couple of major changes in the law coming down the pipe, at least one's coming and one may be coming. The first one is the change of the amount of an estate that is exempt from estate tax,
Yes.
which I think currently is set at 14 million or 12 million, somewhere in that range. And
Yes.
set that increase was set back 4 years ago, is set to revert back to closer to $2.5 million, I think. Can you update us
It's going to revert back to $5 million,
$5 million.
indexed for inflation. So it may be 6 or 7 million at the end of the day. We don't know because the proposed changes by Kamala Harris, if she were elected, would propose that the exemption be down to 3.5 million. So we don't know. We know for sure that January 1, 2026, which is a little more than a year from now, the law that Trump put into place in 2017 is going to sunset. And so that exemption amount that is currently, you're right, in the $14 million range, that is going to sunset, and it's going to go back to a $5 million exemption, again, indexed for inflation, so it may be a little bit higher. So even if nothing happens, if they don't do anything, that's what's going to happen. That's already set to change, unless Congress changes the law. And it's happened in two different occasions, in 2010 or 2011, and in 2013. The same thing was set to happen. The law was going to sunset and the exemption was going to be rolled back. In both of those situations, Congress changed the law and made the exemption permanent. So we don't know what's going to happen at this point. A lot, I think, is going to depend on who wins the election. So we don't know what's going to happen, but it's really important to plan in case that does change, because people who have estates large enough now where today they may be exempt from estate tax if they passed away, after 2026, when the exemption rolls back to a $5 million exemption, they may be in a situation where they will have to, their children may have to pay estate taxes. So it's important to plan ahead.
And you can't really get depressed or really focus everything on that change, but those are the cards that appear to be set to be played out. I think it's likely, no matter what happens, that the increase will be extended, just because I think now almost all congressmen have estates over the $5 million figure. So I think they're more sympathetic than they used to be. But anyhow, I don't mean to get political there. But I guess my question is more emotionally. You must have customers that are panicked about it. You have other ones that aren't panicked. But how do you kind of advise people to approach that, possible change, likely, unlikely? How do you kind of counsel people to think about that? It's a year and a half away, but if you're writing a state plan today, theoretically it's in effect, or the strategy is in effect now for the next couple of years. So how do you kind of counseling people to assess or manage that risk?
Well, we've been talking about this for years. We've known since 2017 that this law is temporary, right? That the exemption amount is going to be rolling up, indexed for inflation. It started out at 11 million when Trump made the law, but it's been indexed for inflation. Today it is what it is. But we've been saying that, hey, this is not permanent. This is something that is going to go away in 2026 unless the law changes again. So it's really important to keep that in mind. And so when we're ready to do reviews, we need to discuss that. And we've been discussing with our clients as they come in. We encourage them to call us before that date, and we'll be sending letters out before the end of the year to let our clients know that this is coming and that it'll be important for them to schedule an appointment to meet with us to plan for that. Yeah. And now is the time to plan, not, 6 months from now or a year from now, because you need time to do that kind of long-term planning.
And then a law recently passed in California, both houses not yet signed by the governor, so you don't really know if it's going to become law or not, is proposed changes AB 2016. Have you been following that at all, or do you wait till it's into law before you start really focusing on that, or how do you see that?
So what is, I'm not familiar with AB 2016.
Oh, so it basically really kind of modifies the small estate. It raises it. I think it exempts personal residences up to their 500,000 or 750. So it's really going to streamline certain routine, lower priced probates theoretically. But I also think, from what I see, that it's going to create great opportunities for fraud, because if you have a streamlined process, it's easier for a criminal to get something through the court approved, sell the house, take the cash and run. And so it just seems to me that good planning would be to make sure you avoid that probate process so you don't get it stolen, would be one option. So whereas maybe you might say, do an estate plan if you have a house of $1 million or more, and maybe not if you have a smaller home. Well, if that smaller home is important to you, maybe it's a good reason to put in a trust so that you don't have that same fraud probate process. I think we're gonna see a lot of, if it goes through, I think we're gonna see a lot of fraud. It's just too easy to streamline probate, I think, a house and get that through, but we'll see. So, okay. Hey, just real quick for those watching, this is Probate Weekly. We do this every Thursday morning, 9:00 a.m. If you want to join the Zoom, you can register at probateweekly.com. There's no charge. We have a Facebook group to continue the conversation. But if you go to probateweekly.com, just put in your email address, you register. And if you scroll down, you can also register to get it in your favorite alternative formats, audio, and or see the past episodes on YouTube. And then when we're done, you can continue the conversation on Facebook, Probate Weekly. You can also post your probate-related or estate planning related content there to get more views, more engagement, look for referrals. This is part of a national platform. We have 3,000 real estate agents across the country who watch our videos, have signed up in the past. So if you're looking for attorneys or real estate agents and probate real estate across the country, great place to converse. Really excited to have our guest today, Paul Velasco, Velasco Law Group. VelascoLawGroup.com is a website. We'll have all that in the show notes down below. You also can call phone line. And Paul is really one of the leading probate attorneys, estate planning attorneys, and probate litigators based in Long Beach, has a whole firm, whole team. Sometimes it's a one-man band, but in his case, it really is I think he's the general of a pretty good sized army down there in Long Beach, what I've seen. And again, as I start from the very beginning, he's been an attorney who I think is one of the leaders of educating our marketplace, both real estate agents and his fellow attorneys. And that's how I met him along the way. So Paul, let's talk a little bit about your business. You're not only, a probate attorney, but you're also a small business owner. Talk a little bit about, how do you work on business development? Is your business kind of on cruise control based on your reputation now? Are you actively out doing business development? And if you do, what kind of activities do you use to build your business?
Well, so over the years, and I've been doing this for 27 years now, coming up on 28. And over the years, I've built my business mostly through networking. So in the beginning, before the internet was a big thing, we just did a lot of networking, just meeting people at events that I met you at, meeting people through professional networking groups like Provisors and others. And so just through those general associations, and many of my referrals come from other attorneys who don't do what I do. So just getting to know attorneys and other professionals, much of that just comes to be just comes to me through those professional relationships that I've had in the past. So I really focus on that and have focused on that throughout my career. But also I give, as you mentioned, a lot of presentations. So I've given presentations to real estate professionals, to CPAs and other attorneys and other organizations. And because of that, I'm kind of seen as the expert in what I do. And a lot of times I'll get calls and referrals through that as well. So I've been doing it so long now. And in fact, I get referrals from people saying that this person referred you, and I don't even know the source of the referral. They've just either heard of me or they've found out through some other source. Some of that comes online as well. People, as you know, more and more will look for attorneys online. And so we've got a pretty good web presence. But I think just, it's kind of like a snowball. It just kind of gathers momentum, and over the years, things just come to you. And so I don't really have to focus on much on, business planning, on that kind of thing anymore, or business development. It just kind of comes now, a lot of the work that I've done.
So one of the things I would point out to people who are watching, if you go to his website, and this is one of the things when people tell me they have an attorney, I always look for what are the practice areas. And there's always a drop down with, 4 to 6 to 10 areas. But really, if you look at all of these are all either probate or how to avoid probate. They're all kind of variations of those options. You don't see DUIs, you don't see criminal, you don't see bankruptcy. So it tells you he really is focused. And then I think the thing that he said, it's a little subtle, but to pick up, is there are attorneys who are in other areas. There are criminal attorneys, bankruptcy attorneys that don't do probate or avoiding probate, estate planning and such. And they appreciate, as an expert in their field, experts in other fields. And so we as realtors have that same opportunity. I've done the same in my business, attempt to kind of copy that format as an expert in probate real estate and kind of avoid kind of the standard retail real estate, which is a business that, I can do, but it's just not really where I'm going to add more value to my customers. And for those of you as realtors, learning how to interface the space, I think, is a great opportunity. Sniffing out the experts is pretty easy when you go on a website like that. You know exactly where they are. So let's talk a little bit about Paul. I'm sure that you not only get referrals from real estate agents or customers that come along with real estate agents. You have transactions where maybe your customer is not choosing the realtor, somebody else is, and you watch the business. What are some of the best practices of real estate agents in probate business you've been involved with? Particularly contested cases where there's maybe the objectors and there's litigation, maybe it needs a court confirmation. What are some of the best practices you've seen, and what are some of the practices that realtors should avoid?
Well, the practices that work well with us are this. Number one is that, most of the estates that we deal with, whether it's a trust administration or probate, have real estate, and something has to be done with that. That property typically is going to be sold. And so we don't do that. we're not professionals in marketing and selling real estate. And so we rely on the professionals either that the client brings to the table and we work with them, or if the client doesn't have anybody and they ask for a referral, we will refer them to the people that we work with. And we have chosen over the years to work with the professionals, and we're not beholden to anyone. There's a number of professionals that we've referred to over the years and that we refer to, but we like to work with those people who are very resourceful in what they do. In a lot of the matters that we deal with, it's not a straightforward sale. A lot of times there's situations where there's a beneficiary that's living in the property, for example, and refusing to give access. And now there's the steps that we have to take to get that person out. And a very good proactive real estate agent will actually get in and get involved and, for example, contact that person and say, hey, what can we do? Cash for keys, or we can do, there's any number of ways that it can be resolved short of litigation, right? Short of a UD action, which is very costly and time consuming. So people who are resourceful, who help clients to step in there if the property is a hoarder property, or if there's situations or problems, they have resources that they can help. If there's work that needs to be done to the property, they can lead the client and say, these are the people, these are the resources we have to help maybe put the property in a condition that will get a better return. And so people who are very proactive, who meet with the clients, and where there's issues or problems that have to be resolved, they step in and they're very resourceful in getting those problems resolved. So it's not just representing the client in the sales transaction or marketing. There are other things that need to be done, often in estate and probate matters and trust administration matters. And if they can have the resources and the skill set to be able to deal with those, and I don't have to do that, it saves me and allows me just to focus on the legal aspects of what I do, and it saves the client money because they don't have to pay my fees to take care of those issues that may come up. So that's what we look for: somebody who's proactive, who's very resourceful, and who can lead the client through problems that you may not find or encounter in other sales where you're just representing individuals and there's no probate involved or trust administration involved. So that's what we really look for and focus on.
One of the areas I think
in terms of what people should, what realtors should avoid, a lot of times realtors will contact me and just a cold call and just say, this is what I do, or an email or a letter. And those don't really work too well for us. I think the best way to do that is to contact an attorney and say, look, I'm working in the real estate field. I have many clients who, as they purchase their houses, we would advise them to get trusts, and I'd like to a little bit more about your practice, and I may have some referrals for you. So if you approach them in a way that you may be able to help them and benefit them in some way, they'll certainly be more open to talking to you and to maybe a way to get your foot in the door. And you don't have to be disingenuous about it. You can be, most of the people who contacted me that way are very genuine, and they really want to have a resource to be able to refer their clients, and they want to know a little bit more about me. But that's the people that I've spoken to, the people who I've has taken the time to set meetings with, or phone calls or Zoom calls, or go to lunch or breakfast with and grab some coffee. But that's the best way to approach attorneys, in my view.
One of the difficulties that realtors face sometimes is they have a transaction, involves probate, maybe it's a confirmed case, maybe not, but still there's a proper procedure, paperwork has to get done. They have questions, and on one hand, the attorney doesn't have to train a realtor. On the other hand, the customer has to get the service done properly. That's a fine line between, asking a question, and you always wonder back in your mind, is the customer being billed for my question? If I send them an email or call the attorney, am I costing money? If you're counseling, let's say, a nephew in another county, it wasn't, let's say, in your backyard, but maybe they're in Northern California, San Diego, how would you kind of coach them up on where's the line between good communication, reaching out, and then crossing a line where you become a burden to the attorney or the firm and you're not really doing your job? How would you assess kind of where to operate there and both be productive but not be unproductive?
Yeah, well, look, I mean, are you talking about like the real estate professional calling the attorney?
Yeah. I have a listing and I have a question on it. Do we have to do a 15-day notice of proposed action or publication or something like that? I have a question or two, and there's a line, but sometimes I feel like when I call, the attorney's upset that they don't want to train me. And I'm saying, well, I don't need you to train me. I'm just asking the status of a filing or a notice. This hasn't been done yet and it has to get done. So I'm always trying to find where's the line between being proactive and then the attorney saying, well, I'm not getting paid to train you on your job. Of course, other agents are newer. Maybe they don't know. And they want to ask the attorney, hey, my client selected me to sell the house. But I have a question. What disclosures do you need in addition to the realtor, if anything, disclosures? What do you need done, or what wording do you want to see in the MLS? So where do you draw the line between kind of communicating effectively and then communicating too much and becoming a administrative burden on a transaction?
Yeah. So most of the professionals that we work with, and a lot is going to depend on the approach of the attorney, right? And how the attorney works. We have a paralegal, a senior paralegal in our firm who's been doing this for about as long as I've been in practice. And he knows probate inside and out. He knows all of the deadlines. He knows all the timelines. He knows everything. And so we rely on him as a resource, and he often communicates with those real estate professionals and others to answer their questions, to lead them through the process if they're not familiar with it. So we don't take the approach that, hey, you should know your job. We understand that this is different. Probate's different. And everybody starts somewhere. It may not be the first time they've done a probate, or maybe they have had probate experience in the past, but for this particular issue, they don't have experience. So we don't treat them as being a nuisance. We're happy to help out, happy to help be a resource to them and guide them. Most of the professionals we work with, however, do have that kind of knowledge and expertise. So I never really feel like, whether it's a real estate professional or a financial professional, and they're working on this case, we're all a team. We're working together. I know my lane. I stay in my lane, and I focus on what I do. And when the client needs other resources, we refer those out to those resources, and we work together with them for the betterment of the client. So we don't think of that. I mean, I don't personally, and I know my staff and team doesn't think of that as a nuisance. Have there been situations or a few cases where it can, the particular person we're dealing with is a little bothersome, or maybe they're not listening and we're saying this is what you got to do and they don't do it? That can be frustrating, right? But those instances are few and far between. It doesn't happen very often. But yes, knowing, if you have that knowledge, that expertise, if you want to go to classes or somehow brush up on those kinds of sales, probate sales, or if it involves a trust, what are the differences? And you have that expertise, it's going to make you all the more valuable to an attorney who's involved in the situation, and more likely for that attorney to refer to you in the future.
I think one of the pieces of gold kind of in that answer also is, for administrative matters, get to know the paralegal. Because like you said, they're the ones who really deal with the paperwork and the filings and the deadlines and the paperwork. And ask you that question, you might just turn to them anyhow and ask them the question. So I might as well go to the paralegal in the first place. And that's really where that question goes. And I think you helped me formulate an answer, which is also, and then come the attorney was more strategic. How do we deal with this heir who's now objecting or causing a problem? They were on board all along. Now all of a sudden they're complaining about the transaction, and we're faced with possibly, a court confirmation issue. How do we avoid that? Those are questions of strategy that I think you need to get the attorney involved with at that point, rather than, is this form right, or what kind of paperwork do you need? Okay, so just last call for questions. You guys are welcome to jump in either in the chat box, or if you're watching on the Zoom call, you're welcome to raise your hand or come in video, and we're more glad to ask questions. That's part of why we moved this Zoom call was from the prior format, was to include personal interaction. So this is your chance to do that. And then just some real, again, just housekeeping. This is Probate Weekly. We do this every Thursday at 9 a.m. Pacific time live. And we do this via Zoom call. You can come and register at probateweekly.com. Just put in your email address, register, and then you can scroll down to get it in other audio formats, or see the past episodes in YouTube. I think this is the largest probate real estate podcast. I'm pretty sure it is, based on the multiple formats and YouTube and such. So love to have you guys participate. We do interviews almost all the time, almost every week, different professionals, attorneys, and from around the country. And then if you want to continue the conversation, go to Facebook. Our Facebook group is Probate Weekly as well. Go there. You can post your probate or estate planning content, as well as ask questions and look for referrals across the country. If you're looking for an attorney or a real estate agent, we have over 3,000 agents around the country. I think 4,000 in the Facebook group that you can ask questions on. And lastly, again, thanks to our guest, Paul Velasco, VelascoLawGroup.com. VelascoLawGroup.com will be in the description. You can go online and call and ask questions, but this is an attorney who is really one of the best at both probate and avoiding probate. And if you're stuck in probate, litigating probate, handles all three of those angles in the space, based in Long Beach, but licensed in California, and really does a fantastic job. I'm really proud to have him on the call today. Okay, so Paul, I really appreciate having you on here today. I guess the last question I would ask is, if you had a family member that was getting in the business of real estate, looking to specialize in probate real estate, looking to work with attorneys or wealth managers or investment advisors or accountants in trust type transactions and more complicated legal transactions, what advice would you give them to be more successful in their business?
Well, number one, to educate yourself. I believe there are resources that are available to real estate agents to learn more about probate. There, in the past, I've seen people who are giving classes and who have presenters, attorneys, and other trusted estate professionals who come and talk about the process. So to get educated would be number one, right? Just get educated about the process. Maybe even mentor with somebody who has experience. But also in terms of reaching out to the attorneys, and trying to network with them or get in front of somebody to try and be a resource for them. I think, as I mentioned earlier, the best way to do that is by contacting the attorney, but in a way that says that, hey, I'm available not only for referrals from you, but also primarily I'd like to get to know you a little bit better so that I can be comfortable referring clients to you and tell me a little bit more about your practice and what you do. So I think that's the best way to try and get those kinds of resources. I know there are other resources out there where people can go and find out about a probate that's been filed, for example, and there are those kind of lists. And then the real estate agents use those to kind of cold call either the executor or the administrator or sometimes the attorney as well. And I don't really pay too much attention to those. I appreciate their efforts, and it's great they do that, but I'm going to go with somebody that I know if there's a referral that's needed. So yeah, I think being educated and trying to be a resource for others it always comes back to you in some way.
When I was married, the rabbi who married us gave us great advice. I don't know that I follow it, but I remember it, and I coach other people on it. I've been married 38 years, barely by the skin of my teeth. But I remember this phrase, which is the key to success in marriage, and I think in any relationship in business as well. The key to success in relationships is not finding the right partner, it's being the right partner. And so on this channel, I've really tried to help challenge real estate agents to up their game on being better resources to their customers, homeowners, and to their prospective referral sources, attorneys in this case as well. So based on that, Paul, you've been a great example of that. Like I said, I met you. And I don't think I give it justice. I saw your presentation, and forever when I talk to attorneys, I can speak with education about a Hegseth petition. I can use the term, but more importantly, I understand the possibilities, the limitations of it. I've given attorneys your sample out, after that event. People ask for it. And I think that the education becomes a tool in your toolbox that is much more valuable than cold calling. So I really want to say you not only gave us that advice here today, but that's how I met you. You really walked that walk. And on behalf of the realtors in the marketplace in the Southern California area, I'm going to thank you so much for being that example.
You bet. Thank you. Thank you for having me again on your show. I always appreciate the opportunity to come and talk to you about that. You're so knowledgeable, and it's great, I think, information out there for the other real estate professionals who are looking to kind of break into the probate world. And it's a great gig because you're dealing with situations. What I do deals with situations where people are passing away, deals with death and taxes, and it deals with people fighting over money. And that's something that is job security. It's never going to go away. So it's a really good area to break into if you can.
Well, thanks again so much. And you get the valuable two-time guest coffee mug for being on again. So thank you so much, Paul, for all you do. And for the rest of you, thank you all for joining in today. Again, this is Probate Weekly. We do this every Thursday, 9 a.m. Pacific time. You can come in on the Zoom call, register at probateweekly.com. Just put your email address. You can come in. And then we also replay this on YouTube and Facebook and Twitch and X and all the other social media. So thank you so much, everybody. I'm at Bill Gross Probate. Have a great week. We'll talk soon. Bye-bye.
Goodbye.